All right. Uh, Mike, we've got the side by side on the screen, also on our committee page showing the amendment that we passed several weeks ago to S-124, and then on the right side, what came out of House Environment yesterday, which is a little different.
Yeah, this is Mike O'Grady with the Office of Legislative Counsel. There are, I would say, about 12 changes in the House Environment proposal when compared to your proposal. There are three very substantive changes, and then the rest are conforming changes based on one of the substantive changes. I can focus on the three big substantive changes, or I could just walk through all the changes.
Yeah, I think maybe just hearing, maybe even before pointing to them if you want, however you want to do it. But yeah, I think hearing about those three would be good.
Yeah, let's go to page 24, the side by side. This is the one.
Question.
Just for clarification, this was Senate miscellaneous ag started out as.
Yes.
Yes.
Yeah.
Okay.
Yeah. S-124. Yeah.
So a large part of the conversation in the House Environment is language related to the powers of the Secretary of Natural Resources and how far she can go in adopting additional rules and under what authority she could do that. And so you will see this language in 10 VSA 1352. It's new language, but it gives her the ability to implement the Federal Clean Water Act to administer a Vermont Pollution Discharge Elimination System (CAPO) program. You had that is consistent with and equivalent to the Federal Clean Water Act. The House Environment Committee is saying that it should be at least as stringent as the Federal Clean Water Act. And what that would mean is that the Secretary under your proposal would be limited to being equivalent to the Federal Clean Water Act and its rules. But under the Environment proposal, the Secretary could be more stringent or have additional requirements than what is under the Federal Clean Water Act and its rules. The Agency of Agriculture and ANR sent a letter saying that they preferred your language, but in discussions with the Environment Committee, it became known that the Secretary of Natural Resources currently, under her current CAFO authority, has the ability to go beyond the Federal Clean Water Act today. So currently, she could adopt rules that exceed the Clean Water Act today. And what would be proposed in S-124 as passed the Senate and in your proposal would limit that. The House Environment Committee didn't want to do that. And so you will see, instead of having is consistent with and equivalent to the Federal Clean Water Act, they have at least as stringent as in two places, and then page 25 in her authority to designate any AFO that meets the definition of the CAFO under the Federal Clean Water Act regulations as a CAFO. There's this reference to or under the VIPTES CAFO rule. And that's the conforming change that is most of the changes in this rule. Whenever there's a reference in this bill, whenever there's a reference in the House Environment Committee proposal to complying with the federal enabling regulations for CAFOs, it then says, or the VIPTES CAFO rule. And that is to acknowledge that the Secretary could adopt, she's not required to, underneath the proposed language, she's not required to adopt a rule, but if she does, she could have requirements that exceed the Clean Water Act enabling regulations or the Clean Water Act itself. So that was really the number one big issue. The second big issue is on page 20.
Here, John.
So Mike, that within that VIPD's CAFO rule, it gives states Secretary of Natural Resources the power to be more stringent.
Yes. So, you know, you and I have been talking about dairy creamer and how you can't be more stringent than the FFDCA and what it sets, because that's what the FFDCA says. But the Federal Clean Water Act and most cooperative federalism programs for environmental protection allow the state to be more stringent than the federal requirements. And so that is, I mean, and the Environment Committee did hear testimony from the general counsel of the agency that yes, the Clean Water Act allows states to be more stringent, and yes, the state generally is more stringent for Clean Water Act regulation.
But our version of it block that stringency.
Right.
Representative Morgan.
But in no case we can never be less than the federal.
You can't, I mean, that's effectively why you are here right now, because CLF petitioned EPA saying that the ANR was not permitting CAFO discharges. They were not doing what they were supposed to. They were not complying with the law. They were doing less. And yes, you can't be less stringent than. There's literally a couple of chapters of rules that sets forth how states have to implement their delegated Clean Water Act programs. And there's one specific to the CAFO. There's a couple specific to the CAFO.
Representative Nelson.
Thank you.
Is some of this brought on that they were afraid of Washington administration weakening the Clean Water Act?
So that is part of it. And you will see a section later on that is intended to not allow the weakening, even if the federal law is weakened. But yes, they were concerned that if it says is consistent and equivalent to, that if the feds weakened the Clean Water Act, then the state program for CAFOs would have to be weakened. It would, in order to be consistent with and equivalent to. And that was Representative Logan is a reporter for House Environment, and that was a concern that she raised specifically.
Okay.
Potential.
Yeah. So, of course, one way around that is you could write complies with the Federal Clean Water Act as you know, pick a certain date like January 5th, 2025.
And that was discussed as well. That was discussed as well, but there is an issue and some ambiguity in the word complies, and I was the one that proposed complies. I think it would need to be complies at a minimum with the Clean Water Act as it existed.
Okay.
To address Rep. Morgan's point that you can't be less stringent than that.
Yeah.
And so I think that's a possibility. That's an alternative.
Okay, and the RAPs currently, as written, we're already more stringent than the Clean Water Act. Am I correct in that analysis?
In many respects, yes. And the key example I give is that the federal CAFO allows an exemption for discharges when the discharge is caused by a 24-hour, 25-year rainfall event. Whereas the state RAP, state ag water quality, does not allow for such an exemption. You cannot have a discharge from a 24-hour, 25-year rainfall event.
And also we have the rules, the waters of the state versus waters of the United States.
Right. As this as you proposed, your committee and as was debated, whether or not the scope of permitting of discharges should be to the waters of the United States or the waters of the state. The waters of the state is a broader universe of waters. So yes, it is the requirements when you apply it to the waters of the state is more expansive than the federal.
Representative Boston, did you have a hand up?
No, I was just,
Representative O'Brien.
What's the difference between NIPTs and VIPTs?
So NIPTES is the National Pollution Discharge Elimination System permit,
EPA.
right? Vermont Pollution Discharge Elimination System permit is the permit that Vermont issues under its delegation from EPA. So it has to comply with all the NIPTES permits, but it's the one that Vermont issues, not EPA issues. And it's set up that way because EPA has generally what's called, what I call override authority. It's not necessarily called override authority for Clean Water Act. They can come in and say they don't like what the state was doing with its VIPTES permit, and they could issue a NIPTES permit. So there's a distinction that needs to be there, that EPA still has that its own permitting authority, its NIPTES authority, where Vermont is complying with the NIPTES rules, but issuing its Vermont Pollution Discharge Elimination System permit.
And so the VIPTs then can be more stringent.
VIPTES can be more stringent.
And if you're not, like sort of now it's being implied, then NIPTs is potentially more stringent, right? And that's why we need to change this.
That's what you weren't complying with the NIPTES rules. So the next big issue in discussion in House Environment was whether there should be a specified schedule for ANR to inspect the large CAFO, medium CAFO, and small CAFOs, and in fact, all farms. And there had been a proposal in the recommendation from the environmental advocates, which is on your website. And instead of going strictly to a statutory schedule, the report back the stakeholder group that ANR is supposed to do, they're going to, as part of that report, propose a plan for inspection of animal feeding operations, potentially subject to the requirements for a CAFO permit. The plan shall include a proposal of which AFOs should be subject to inspection, including whether all LFOs and MFOs must be inspected to determine if a CAFO permit is required. Proposed schedule of inspection of those AFOs subject to inspection, including frequency or events or thresholds that would require inspection, and an estimate of the staffing or other resources that will be required to implement the proposed inspection plan. This was definitely an issue for a couple of members on House Environment. They say that there's already an inspection program at the Agency of Agriculture, and why do you need this inspection program? Well, and then the response to that is, and I think it was Representative Austin read EPA's letter that said ANR needs to be the one that does the inspections. And so there was definitely some tension about how these inspections should be done, who would do it, what frequency, etc. This is a report. It's just a report. Just a report. So there was language at one point that would have set minimum inspection timing, but this does not do that. This is just a report.
A report on a plan for inspection.
Yeah.
And a schedule.
Yeah.
And a personnel estimate.
Yeah.
Okay.
So the next big change is on page 38. Representative Nelson kind of already referenced this. There was concern that if the Clean Water Act changed, it could be weakened, and that any reference to the Clean Water Act in current statute would then mean it was referencing the weakened part of the weakened Clean Water Act. So this is what's being called the clamp, which Representative North came up with that moniker. So it's clamping the Clean Water Act in Vermont and its reference to it as it existed on January 1st, 2025. So notwithstanding statements to the contrary in Title VI and Title 10, which says the Federal Clean Water Act as amended, when the following are referenced in Title VI or Title 10, the text of each shall be applied and interpreted as each public law, statute, or regulation existed on January 1, 2025, regardless of any subsequent amendment, repeal, or other substantive change. So the subdivisions 1 through 6 are how the Clean Water Act is referenced in Title 6 and Title 10. Public law number 92-500, that's actually the official citation of the Federal Water Pollution Control Act, which is the actual name of the Clean Water Act. The Clean Water Act were just a subset of amendments. The Federal Water Pollution Control Act. At my previous job, I wasn't allowed to call it the Clean Water Act. I had to call it the Federal Water. Nobody else ever calls it that. It's the Clean Water Act, but the FWPCA is its technically correct name. Then there's references to the federal laws or regulations related to the Clean Water Act, the enabling regulations of the Clean Water Act, including cites to Code of federal regulations, the federal regulations for CAFO, the federal NPDES system, or federal NPDES. And so those were all of the references in Title VI and Title 10 to the Clean Water Act or its regs. And that would then be repealed on April 1st, 2029. So you would have a legislative session to contemplate how to or what to do with regard to future reference to the Clean Water Act.
Representative O'Brien.
So what happens in the case that, you know, say the current administration throws out the Clean Water Act, like you can clamp this?
It's been clamped, right? And so,
But it's to a federal law that no longer exists.
right, but so there's already language that's moving through other bodies that says when there is, and it's for all public agencies, all state agencies, when there's incorporation by reference into a rule, and that rule is repealed or substantially amended, that it's going to be deemed to be an interpretation to the rule at the time. I can't remember the exact date, but today. And that any rule that's repealed has to be published on an agency's website. Most of these rules, they're not going away. Even if they're stripped off of, say, the Federal Register or Tom or whatever they're calling the U.S. Congress site now. It used to be called Thomas. It's called something else now. There are private entities that maintain these rules, these statutes.
Court decisions too,
right. So these Westlaw will have them. They'll be available to the public regarding what they require.
So, are you with the end here?
Those are the three major changes. If you go through, the rest of the changes are referencing or the VIPDES rules adopted by the secretary. Whenever there's a reference to the federal enabling regulations, it will now say, or the VIPDES rules adopted by the secretary.
Okay.
And so that, and you can probably see that right there.
Okay.
I
think as this appears in the calendar, and it is in the calendar on notice today, it's not a straight ball, which is actually helpful in this case, I think. Maybe 10 or 12 instances of amendment.
It's 4 pages long total.
Yeah. But they are basically fall into 3 major, and so going backwards, the clamp is one.
There's clamp,
there's the schedule,
Inspection plan,
and then
at
there's,
least as stringent as
Least as-
versus equivalent to and consistent with.
so Representative Nelson.
Yeah, as far as the schedule of inspections go, to be fair, there was never a schedule in Title 10 for when a CAFO was created. There wasn't a schedule for inspections. It was in Title 6 for the regular LFO, MFO. Small part.
You were correct, but I think one of the interesting points of what you just said is that there was no schedule for when a CAFO was created. No CAFO was created.
Yes,
And so that's why you're here.
yeah. And I can understand, LFOs are every year.
Right.
Medium firms are every 3 years, small firms are every 7 currently. And if there's a CAFO enacted, they may want to do everyone every year because CAFO is a 5-year plan for correction.
5-year term, permit term.
Top 5-year term for correction, so it would be imperative that they were checking in every year to make sure, how's your plan coming, where you're at, what's going on today. I can,
There are actual inspection requirements under the CAFO, federal CAFO rules.
there is,
When
okay,
you are permitted, it just says that the permitting agency has to have an inspection program. It doesn't say frequency, et cetera.
yeah, okay.
Before we break for lunch, I just wanted to, we can ask any other questions and if anybody has anything, immediate reactions, we can hear those. And then I think we probably should break so we get some time because we don't have any control over when the floor starts. That's fixed at 1. And then if the floor doesn't go too long, then I'm hoping that we'll come back. But go ahead, John.
Mike, just for clarity, and maybe it's just because we're diving into this, when secretaries mentioned it, is it defined as the secretary of A&R? Because we're going back and forth between the two agencies. And it's just, I keep getting confused, like which one are we?
When you're in Title 6,
Yeah,
it's the Secretary of Ag. When you're in Title 10, it's the Secretary of Natural Resources. And they are both defined in those 2 chapters as Secretary means Secretary of Ag in Title 6, Chapter
you're
215.
mentioning the secretary shall do this and this.
Yeah, yeah.
More stringent, there's a reference back.
There's it would be that would be Secretary of Natural Resources.
Right, yeah, okay.
Any other questions for Mike, just about what we have in front of us?
I am supposed to maybe, if they can fit me in, go to House of Probes today, or not House Ways and Means today, about the permit fee for the large KFO,
Yeah, there's a fee.
LFO, MFO.
Have they already looked at this?
No, they
Never
haven't.
did.
They scheduled it like 3 or 4 times.
Okay.
Because it hadn't been out of environment. They didn't want to prematurely review it.
Okay, so that just in terms of the timing, if it's on notice today, in theory, if they don't have a chance to look at it, it will be taken off notice.
It's going to get referred to them
Yeah.
when you go to the floor today.
Yes.
And so they're going to try to take it and act on it today.
Okay.
I don't think it'll go to appropriations, but that's up to Betsy Ann and the speaker.
Will it go back on notice?
And after it comes out of them, it goes back on notice.
Okay, all right. So in any case, it won't be on the floor tomorrow
I don't.
unless something changes.
I don't believe, but you can always call it off the notice calendar, which they're doing in the Senate.
John.
On the proposed report, does that get into, if there's redundancy and the secretary is saying like the people in ag doing inspections now will just move those positions over?
Remember how there's an MOU right now about how they're supposed to interact?
Yeah,
Instead of that MOU, there's going to be the document about how they interact and that EPA has to approve. A lot of that type of detail is going to be in that document,
okay. And that would be part of this report.
probably. Remember, that document needs to be done by September of this year.
In what we've got.
Yeah, and everybody.
In everybody, yeah.
Nobody has changed that.
Okay. All right, any immediate thoughts, committee discussion type thoughts before we break for now? Okay, Mike, thank you for running us through this. Let's see where we are. Is anybody not able to be here, after the floor for, if we take some more testimony? I'd like.
They could be here.
Okay, I think that the agencies might want to, I know we have a letter from them and they just want to emphasize that. And if, I don't know whether the advocates are here and interested, but if we have any interest in taking some testimony, if the committee is available, if